Give evidence as first, and the judge will be taking notes about what the guard's saying. And oftentimes you'll hear a judge saying to the guards, just slow down, I'm trying to write this down. They have to write down what's being said as the witness gives the evidence. And as they're writing stuff down, you'll often see a judge looking at them and trying to assess them just the way you would assess someone telling you a story. You look at body cues, facial expressions, to help you form your view as to whether or not their account is accurate or believable. Judges are no different. And so they're looking at the guard giving the evidence as well as hearing what they're saying. And they'll do the same with you when you give evidence. They'll be assessing you. Accuracy is usually the thing. Most people honestly believe what they're saying, but they can be mistaken. But writing it down straight away is very important, because over time you'll forget stuff. And if you come into court going, oh, I think, more or less, or it kind of was, that's pretty fatal. A tactic that they employ a lot, and I know they employ because I used to do it myself, is where you're arrested for drink driving. And then you get all these summonses. You get drink driving, you get no insurance, no license, no NCT, careless driving or dangerous driving as well, and then you didn't produce your license, you didn't produce your insurance, and now you've got, instead of one charge, you've got 8 or 9 of them. Now you're panicking because you've got so much stuff. But they're only interested in one. The drink driving is the only one they're interested in. The other ones are red herrings. They throw them at you to alarm you. They'll come to you then with an offer. They'll come to your lawyer with an offer and say, well, look, if they plead to the drink driving, I'll strike out the rest of them. And you'll imagine that that's a very benevolent approach to take, but they don't care about any of those. There's only one they're interested in. Other than juvenile cases or family law cases, the media are allowed into court, and they can report on what happens inside in court. Recognized members of the media are allowed into court for even juvenile cases, or rarely family law matters, but juvenile cases. But they cannot reveal the identities of the people involved, or anything that might lead to them being identified. So family and friends and where they live and stuff like that. But they're entitled to be there for other cases, all other cases, because the Constitution says that justice must be seen to be done in public, and part of the public thing is the media reporting on that, because the High Court's acknowledged over the years that members of the public don't go into court every day of the week. They don't know what goes on inside there, and they rely on the media to inform.
That whole system is completely alien to people who don't know it.
It's set up in that way. It's always been that way. Law is set up with all its mysteries and mysterious words and expressions and phrases. And what you find with people when they're inside in court, first of all, they base what they expect court to be like on TV. And that tends to be very, very adversarial. It's also TV, it's not real. It's overwhelming for them. Like, it's people moving around them. You've got guards filing past, you've got prison officers coming in out of a custody area, court clerks standing up, solicitors talking always in a kind of a low voice or using legalisms. It's just an overwhelming experience for them. So it's a lot of what I do is kind of reassuring them.